And Mr. Williams, in cause number 25 DCCR 0985, is charged with capital murder. And Mr. Cashin has filed a motion asking that I reduce bond. We were here either last week or the week before. Reset this case today to give everybody some time to get prepared on that motion. And Mr. Cashin, do you intend to call your client?
No, ma'am.
Okay, you may call your first witness.
Okay, but before I do that, Your Honor, I know some of these proceedings are streaming, and one of my witnesses is going to testify. Can she refrain from using her specific address?
Absolutely. I don't typically require any, just Jefferson County is fine.
Jefferson County, yes.
Yes, sir.
Yes.
Absolutely. We don't need specific addresses ever, or very rarely, from especially a witness.
Okay. All right. I'd like to call Angel Anderson.
Ms. Anderson? And Mr. Williams, if you'll just kind of step around closer to Mr. Cashin, kind of right there. You're good right there, sir. And maybe you can come right up here in the front, please. Good morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You may proceed.
Thank you. Will you please state your name for the record?
Angel Anderson.
And Ms. Anderson, where do you currently reside?
In Beaumont, Texas.
Okay. And how long have you lived in Beaumont, Texas?
For 42 years.
And do you know the gentleman to your left?
Yes.
And what is his name?
Larry Moore.
And what,
Ma'am, can you speak up so that I need to hear you and the court reporter needs to hear you as well, please? Thank you.
and what is your relationship to Mr. Williams?
That's my brother.
So you've known him all of your life.
All my life.
And does he currently reside here in Beaumont?
Yes.
Okay. Are you currently employed?
Yes.
And what do you do, ma'am?
I have a business.
What kind of business?
I have a hair store.
Okay. And that's here in Beaumont?
Yes, sir.
Okay. And how long have you been the owner of that business?
For 6 years.
Okay. And so Mr. Williams, prior to him being arrested, was he working?
Yes.
And how long had he been working?
Oh, I don't know.
And what had he been doing? What type of work?
Landscaping.
Okay. And he, have you ever, do you know what a bond process is?
Yes, sir.
And you know what a bond consists of?
Yes.
And you have to go to a bondsman, correct?
Yes, sir.
And the bondsman wants to be assured of what things?
They were like a co-signer, financial,
And some
and
collateral. Okay. And do you and your family and friends have enough money to post a bond like in the amount of maybe like $50,000?
Yes, sir.
And presently he has a bond that's approximately $10 million. Is that right?
Yes, sir.
And have you all attempted to make that $10 million bond?
No, sir.
And the $10 million bond, that was set by a magistrate like early on in this process?
Yes, sir.
And also his other bond for the aggravated assault case was raised. Is that correct?
Yes, sir.
From what to what?
25,000, if I'm not mistaken, to 100,000.
To 100,000?
Yes, sir.
Okay, so he has approximately $10,100,000 worth of bond. Okay, and if the judge sees fit to place his bond like at maybe $50,000, do you have family, friends to put up the property like collateral as well as money in order to secure the bond?
Yes.
Would you be willing to co-sign on the bond?
Yes.
Do you have other family members that would be willing to co-sign on the bond?
Yes.
Have you been in touch with the bondsman, and do you know of a bondsman that would be willing to go along with the bond for you?
Yes, it's in good standings with his bond.
I'm sorry, I can't hear you.
Yes, ma'am. Being in good standings with his bond he had approved.
Okay, so
I still didn't understand what you said at the end.
He in good standings with the.
Oh, he's in good standing. Okay.
Yes, ma'am.
okay. Have you ever known Larry not to appear in court?
No, sir.
And he has, on the other bond that he had for the aggravated assault, did he ever fail, to your knowledge, to come to court
No, sir, he already came.
He always came to
Yes.
court every time,
Yes.
on time. There was never any problem with him showing up in court.
No, sir, there's no problem.
All right, and, I passed the witness.
All right, thank you, Mr. Cashin. Mr. Smith, any questions of
No
this witness?
questions, Judge.
Thank you, ma'am. You can go back and have a seat. Any other witnesses, Mr. Cashin?
No, ma'am, but Your Honor, I would like to point out that there are other family members in the courtroom
Yes, sir.
that are of adult age. Tanisha Williams, his daughter, who is present in the courtroom, she would say the same thing that Ms. Anderson just said, as well as his daughter, Laridra Clay, who's also an adult, and she would say the same things and would confirm with what Ms. Angel just now said.
Thank you.
Presently, his bond, which I feel is
Mr. Williams, you can step back around, sir.
Presently, his bond, which I feel was emotionally set at $10 million. I think that is very excessive and is very punitive. And Mr. Williams, although he has had some issues with the courts and the judicial system, he has never, ever failed to appear in court. And I think that because of, I think that his prior attendance in court, his prior taking care of all of his court business shows that he is not ready to flee, he's not ready to run, that he will come to court and face the charges and face whatever the court requires of him. A monitor would be sufficient to maintain his location, like with the GPS. He does need to work, so I would not like to request that he be placed under house arrest, but I think he should be able to have maybe a monitor or maybe some curfew hours as opposed to a $10 million bond. I think a reasonable bond for a case like this should be about $50,000, and I would like to request that the court set his bond at $50,000.
Okay. Mr. Smith?
Judge, the state is opposed to a reduction in the bond. This capital murder is based on the fact that we were coming up for trial. The murder of the victim, who was also the victim in the aggravated assault, occurred very shortly before that was actually going to be called for trial. And the fact that he fled after committing this murder to Houston and had to be located in Houston shows that he is likely to run if given a bond. The family of the victim is also in fear for their lives should he get out of jail, and we'll be ready to proceed to trial as soon as Mr. Cashin is up and ready.
Your Honor, in regards to what Mr. Smith just said, Mr. Williams, when he was located in Houston, was on his way to my office. And that's the reason he was in and around the Houston area, because he was coming to my office to consult with me because he had heard on the news reports about this alleged murder, and so he was coming to talk to me, and he was not in the process of fleeing, but he was in the process of coming to consult with me about the situation. So I think that by alluding to the fact that he was arrested in Houston is like kind of a stretch, because he was attempting to meet me at the office.
All right, so obviously this case is the date of this case precedes any modifications that happened in our legislation this last cycle that have come into law as of yesterday. One of those is actually that it is appropriate, and if someone is out on a bond for a felony offense and the allegations are that they commit another felony offense, to have no bond, which is something that is more strict instead of more lenient with regard to bonds. I believe the fact that Mr. Williams has come to court when required obviously is nice and great, but the fact that he's the allegations are that, and if they're allegations, he hasn't been found guilty, but I am entitled to take into consideration the underlying facts of the case. And so based on the the offense that he was charged with initially, the aggravated assault, based on the fact that this new allegation is that the victim or the complaining witness in that case is now the victim in this alleged case. I do not find that it would be in the best interest of our community to grant the motion, and I am going to deny that motion to reduce bond. We will get the case moving as quickly as possible. I get with Mr. Smith, and again, just like we talked about before with regard to any issues, just let me know if there's any issues with regard to discovery, and I'll set it for an announcement in about 30 days,
Yes.
give y'all some time to see where you are.
Yes.
And then again, once it's ready for trial, if it's going to be a trial, we'll get that done as quickly as we can.
Yes.
All right, you can go back with the bailiff.
Thank you.
Good morning. Morning, Ms. Malfino.
Good morning, How are you?
Good, thank you. Let's see. Okay. So, she was ordered a safe P already. Does she go and,
She was unsuccessfully discharged from the aftercare, the Melton. She left the Melton Center.
so the agreement is to go back to, for relapse? Does it need to be is there a special needs relapse?
Yeah,
Okay.
special needs. She's got a lot of under.
Sure. Ms. Washington, the best you can, raise your right hand for me, please. Do you swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, and will she waive the formal reading of the motion?
Yes, Your Honor.
Ms. Washington, in cause number 23, DCCR 1036, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 10th of 2024 for harassment of a public servant, and that was a 2-year deferred probation. Is that correct? It alleges you violated your probation. Count 1 alleges that you failed to report as directed to the probation department June 2nd of 2025. And is that true or not true? Count 2 alleges that you failed to enroll in services at the Spindletop Center. Is that true or not true?
I didn't tell me nothing about the inmates and more services, but I can do it though.
Okay, so we'll do not true for 2. Count 3 alleges that you're behind in your court-assessed fees.
Yes,
Is
ma'am.
that true or not
Yes,
true?
ma'am. Sure.
True. And then count 4 alleges that you failed to successfully complete the safety program, including the aftercare. Is that true?
Yes, that's true.
Okay. Did you enter your plea of true to counts 1, 3, and 4 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
So it's my understanding, Ms. Washington, that probation feels like you still deserve a chance and that you have the ability to take advantage of some services and be successful. I want to make sure you understand from my standpoint. I have no doubt that they have let you know about everything, okay? From the very beginning with regard to SafeP, with regard to any special services through Spindletop. If you don't take advantage of this opportunity this time, and you're back in here because you didn't go and receive services or you don't successfully complete the relapse program at SafeP, we're not going to be talking about keeping you on probation. You understand? You could go to prison for 10 years today for violating your probation. It's that serious. So you need to make sure you take advantage of everything they have to offer you, okay? All right. So
Would the court consider maybe extending?
I'm going to have to, yeah, for sure. It's going to be extended, I would think, by at least 2 years. So, I'm gonna make your probation go longer because you gotta go back through SafeP now, so it's gonna take longer. So you're gonna have to prove that you can be successful, so I'm going to extend your probation.
Okay.
Hold on just a second. So, here's another thing that's very important. Your behavior in the jail is something that I find out about. Okay? I get incident reports.
Yeah.
And hang on. And it explains every time you get an incident report, every time you're calling a correctional officer the B word, every time, hang
I
on.
wasn't on my medicine.
Well, and I understand that there might be some issues, okay? But I want to make sure that you do the best you can
Yes, ma'am.
to follow all of the rules and not be disrespectful.
Okay.
to anybody that's in there just doing their job and trying to help, right?
Yes.
They're just going to work every day,
Yeah.
okay? They don't deserve to be treated that way. That includes when you're in safe P. Because if you get to safe P and you're on your medicines and everything's correct and you're acting like this, then you're going to end up getting revoked before you ever get out. Does that make sense?
Yes, ma'am.
Okay. So I'm going to find that you entered your pleas of true to counts 1, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow this agreement and I'm going to extend your probation for 2 years. And I'm going to order that you enter and successfully complete the Special Needs Relapse Safety Program. Obviously, when you get out, you will be required to go to the Spinal Center, be evaluated, follow through with any recommendations they have of treatment or medication or whatever it is, and all of that is so that you are successful, okay?
Okay.
All right, good luck to you, ma'am. You can go back with the bailiff.
Have a blessed day.
Thank you, ma'am. You too. Good morning, sir. Are you Donovan Spencer? Good morning, Mr. Smith. Give me just a second. And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Well, it's coming. Hopefully. Did they? Good morning.
Good morning.
Okay. Mr. Spencer, in clause number 24, DCCR 0261, I have a motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for assault on a peace officer, and that was a 10-year term in prison that was probated for 10 years. Is that correct? And it alleges that you violated your probation. Count 1 alleges that you failed to report as directed July 8th of 2025, and is that true or not true?
True.
Count 2 alleges that you failed to complete the mental health evaluation and follow all of the recommendations, and is that true or not true?
True.
Count 3 alleges that you failed to successfully complete the SafeP program. Is that true or not true?
True.
And then count 4 alleges that you failed to submit to an alcohol or drug screening July 1st of 2025. And is that true or not true? Did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is to cap your punishment at 6 years. And so what that means is that we will reset your case. I'll get an updated pre-sentence report. We'll come back and see. I'll get any evidence that's presented, and then I'll decide your sentence. And as long as I do not give you more than 6 years in prison, you can't appeal that. You understand? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Spencer is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he will present it to me on your behalf when we come back. All right, we'll see you back at sentencing.
Thank you, Judge.
Thank you. And we reset Wilkerson. Good morning. Are you Traven Alexander?
Yes, ma'am.
And this is 25 DCCR 0831. Mr. Alexander is charged with murder. And Ms. Perazzo, what is the announcement?
Your Honor, we have not quite completed reviewing all of the discovery, so if I could just have
Sure.
additional
This
time
is-
to review.
Yeah, just indicted, it looks like 40 days ago. Okay, and so, Mr. Alexander, what I'm going to do is reset your case about 30 days or so to give Ms. Perazzo some more time to make sure she has all the discovery from the district attorney's office. She will be out there to go over all of that with you before the next court date, everything that she has, and then we'll see if we can get an announcement at that point. Okay? All right, you can go back with the bailiff. All right, sir, you're Lenny Lede?
Yes, ma'am.
And this is 23 DCCR 0783, and Mr. Lede is charged with sexual assault. There was a withdrawal. We've gone through a couple of attorneys. Mr. LeBlanc has been appointed, and Mr. LeBlanc, what is the announcement?
Judge, as far as I understand, his plea is still the same. We're getting ready for trial. I've gotten with his other attorney and got the information from him.
Okay.
And so it's,
No change in any offers or anything like that. All right, so Mr. Lede, what I'll do is move your case back onto the trial docket, and Mr. LeBlanc will continue getting ready for trial, and we'll get it tried as quickly as we can. All right, you can go back with the bailiff. Thank you, sir.
Judge, just for the record in this case, Cherie Drake was sent a subpoena and a letter separately. She received both. She did call our office, said she did not want to come, said she doesn't care what happens to the defendant, and that she had other things going. So with that, state will file a motion to dismiss.
All right, so I'll sign that. So, Mr. Caddy, I'm not sure what the relationship is going forward with Ms. Drake, but I'm looking at the probable cause affidavit in your case, and it's not pretty, what the allegations are that you did to her. And if you get out, my suggestion is you go do your own thing without her, and you learn to keep your hands to yourself when it comes to whoever you're dating, okay? Go back with the bailiff. Good morning, Ms. Cepeda, thank you. And would you please raise your right hand? Do you swear to accurately and truthfully translate from Spanish to English and English to Spanish, so help you God? Thank you.
Did you understand anything about the email?
No, he did not. He just said he was not sorry.
Okay.
Yeah, that's fine. If you need to talk to him, he moved down a little bit.
Good morning, are you Jose Lopez Pamias?
Yes.
And Mr. Pamias' case is set for trial to begin with jury selection next Monday. And what is the announcement?
The defense is ready, Your Honor.
And on behalf of Mr. Coleman, the state's ready as well, Your Honor.
All right, Mr. Pamias, I want to make sure you understand that after today, I will not accept any plea agreements. So I want to make sure you still want to reject the state's offer and go to trial.
They don't give me anything good.
Well, the offer was 25 years on one case, dismissing the two other cases, and 25 years if you go to trial and are found guilty is the minimum punishment. Because of your prior felony convictions. There was also an offer after that where the state offered to waive the habitual offender status and allow you to plead open to the court to a second degree felony, which means that you would leave your punishment up to me, and I could sentence you anywhere in the range between 2 and up to 20 years in prison. So do you want to reject that and go to trial? Or take that offer?
I cannot give up my innocence.
Okay, then we'll go to trial next week. I'll number the cases after docket.
Yes, ma'am.
Thank you, Ms. Cepeda. Good morning, you're Rebecca Rideau. And this is 25 DCCR 0336. Ms. Rideau is charged with tampering or fabricating physical evidence with intent to impair, and what is the announcement?
Your Honor, what do you want to take it off?
Y'all go talk about this somewhere else other than in front of
The
me.
last time I spoke with her, she didn't want to.
Okay.
I want to make sure. No.
Okay, go have a seat in the jury box. Y'all talk about it before you get in front of me. She's in the back. You can go visit with her before you stand in front of me. Mr. Kimler, on Gabriel Smith. or-
We talked to you.
This is recent, can we consider?
Yeah, that's what she wants to do.
Go talk to her in the back before you come up here. I want. Well, then just ask me to hold them for a minute. I'll hold them. Go visit with them. You were just sitting in the jury box. I figured you were ready. Good morning. Are you, is it Zabaris? Zabaris Harrison? And Mr. Lewis, will your client waive the formal reading of the motion?
He does, Judge.
And Mr. Harrison, the best you can, would you raise your right hand, please? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. And will he waive the formal reading of the motion?
He does.
And Judge, with the court's permission, we would move to abandon what should be number 4 with respect to the fees. It looks like there's some typographical errors on there.
Oh, okay. Thank you, ma'am.
And just move on 1, 2, 3.
Okay. I have a motion to revoke your unadjudicated probation, and this is 23 DCCR 1410. It shows that you were placed on probation July 22nd of 2024 for the offense of assault, family violence with previous convictions, and that was a 4-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed February 11th, March 11th, and April 24th of 2025. And is that true or not true? Count 2 alleges that you failed to provide verification of performing the community service as ordered. Is that true or not true? Count 3 alleges that you failed to provide verification of entering and successfully completing the BIP program, the Battering Intervention and Prevention Program. Is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? And did you plead true to those because you actually did what they allege? All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case so the probation department can do an updated report. That'll give me more information about you and what's been going on with your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. Okay? We'll see you back at sentencing. Unagreed. There's that too. Good morning. Are you Gerald Jackson? And this is 24 DCCR 0706, 0707, and 1170. Mr. Jackson's charged with credit debit card abuse in 2 of those cases, and then theft of property in the other. And what is the announcement?
Judge, I've talked to Mr. Jackson about the situation. There is some information, a video, as well as other information that his family has. They're getting to me. I talked to them up until this morning because she was able to send me some screenshots, but she was trying to retrieve the actual video from her iCloud.
Okay.
So hopefully they'll have that, hopefully today sometime.
Okay.
As well as he's currently on a probation in Harris County, and I think they've already reinstated him even though they knew about these allegations.
Okay.
So his probation officer there was supposed to give me some information because they had some amended conditions and things like that.
Okay.
Including someone to talk to Mr. Coleman about that.
Okay. All right. So what I'll do, Mr. Jackson, it sounds like your family's trying to get Mr. Lewis some information, so I'm going to give them some time to do that. I'll just do a normal reset. That should hopefully give everybody time for you to get what you need from probation and the family, get that to Mr. Coleman, and then we'll see if we can get your case taken care of at the next court date. All right, you can go back with the bailiff. Mr. James, in cause number 22-39926, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 3rd, 2022 for the lesser offense of an attempted unlawful disclosure of or promotion of intimate visual material, Class A misdemeanor, and that was a excuse me, a 1-year deferred probation that had been extended for 24 months. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to pay your court-assessed fees as directed, and that as of June 24th, 2025, you were $823 behind. Is that true or not true?
Before I turned myself in, I paid $500 on my probation fee.
Okay,
He's still behind about he's behind about $325 or so.
okay. So if I make that it's true that you're behind, but just to $500 less than what they allege?
ma'am.
Okay. Minus 500. All right. And then count 2 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a sample May 15th and June 24th that tested positive for alcohol. Is that true or not true? Okay. Did you enter your plea of true to count 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am, I did.
And do you fully understand them?
Yes, ma'am, I did.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. James is not competent? All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of attempted unlawful disclosure or promotion of intimate visual material. Sentence you in accordance with your agreement to 120 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. Good luck to you, sir. You can go back with the bailiff.
Good, this one with the Board of Commission, we've agreed to proceed on as a Class A, just due to some other facts of there being some usual combat between the parties.
Okay.
Just so the court is aware, there's no criminal history, except for one instance I can find that dates back to 1998.
Thank you, ma'am.
Thank you.
Good morning, sir. Are you Moses Jones Jr.?
Yes, ma'am. Good morning, Your Honor.
Good morning. And Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Jones, in cause number 25 DCCR 0848, the state has elected to proceed. Can you hear me? You're having a hard time? Is that better? Is it better now?
Yes, ma'am.
All right. So in cause number 25 DCCR 0848, the state has elected to proceed on the lesser offense of a Class A misdemeanor assault family violence from June 15th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with in that lesser offense?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And are you a U.S. citizen?
Yes.
State tenders number
No
1.
objection.
It's admitted. Is any evidence that Mr. Moses is not competent?
No, Your Honor.
All right, Mr. Moses, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor, assault family violence. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody. You'll get all that credit. You'll get all the credit that the law gives you the right to receive. And I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. There are some rules with regard to that because it is a family violence assault, even though it's a misdemeanor. So if you have any questions about that, you can talk with Mr. Parker Read that document I gave you. It will also explain to you all of the factors that go into your ineligibility to possess a firearm or ammunition. Because if you do possess one and you're not supposed to, then it could lead to further charges. Do you understand? All right, good luck to you, sir. You can go back with the bailiff. Ms. Thomas, I have a motion to revoke your unadjudicated probation. And it shows that you were placed on probation April 25th of 2016 for the offense of forgery, and that was a 5-year deferred probation. Is that correct? Yes, ma'am. It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department August 20th, August 28th, September 13th, and October 10th of 2018. Is that true or not true?
It's true.
And then count 2 alleges that you failed to provide verification of performing the community service hours as directed. And is that true or not true?
True.
And then count 3 alleges that you are behind in your court assessed fees. And is that true or not true?
It's true.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
I did.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 5 years in prison. So it means as long as I give you 5 years or less, if I revoke your probation, then you can't appeal that decision. Do you understand? State tenders number 1.
No objection.
It's admitted. Is there any evidence Ms. Thomas is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that the probation department can do an updated report. That'll give me more information about what's been going on in your probation, and then we'll come back at a later date for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker, and he will present it to me on your behalf when we come back. All right, you can go back with the bailiff.
Thank you, Judge. Oh, Judge.
Yes.
She's on deferred and does not have a bond. I told her I would request a bond. She has the ability to get back to work. She's been working and.
I'm up in LA right now, so I'm just trying to get back to work. I work at a nursing home.
Well, you've been gone for 7 years, and so I don't know what's been going on for those 7 years since you've been on deferred probation. Starting in 2016, it looks like you stopped reporting in 2018.
Yes, ma'am.
Based on that, and based on the fact that I have no other evidence at this time, I am going to find that it is in the best interest of society and our community at this time that I not set a bond in your case. Let's get the updated pre-sentence report. I want the probation department to be able to look into what's been going on, and then we'll see what happens at the next court date.
Thank you, Judge.
Go back with the bailiff. Oh, I see. But the, I don't see the registration. I don't see it there either. Hold on, let me double check. There it is. Okay. Okay. All right. You're Andrew Jackson?
Yes, ma'am.
And Mr. Jackson was previously in court, entered a plea of guilty in cause number 23, DCCR 0045. Hold on a second. Which was the offense of sexual assault of a child. The agreement was for 12 years. I did not order a pre-sentence report. Is there any reason not to go forward with sentencing at this time? All right, then, Mr. Jackson, in cause number 23, DCCR 0045, find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of sexual assault of a child. Sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Also, you signed today, and I do want to make sure you understand that as a result of this plea, you will be required to register as a sex offender. You understand that as well? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. It's my understanding that there is a victim impact statement. If y'all will have a seat at council table. All right, thank you, Mr. Coleman. All right, ma'am, again, you're Rebecca Rideau. And Mr. Kimler, will your client waive the formal reading of the indictment?
All right.
Let's see, Ms. Rideau, in cause number 25 DCCR 0336, the state selected to proceed on count one only. It alleges you committed the third-degree felony offense of tampering or fabricating with physical evidence, and that's from October 2nd of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow this agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Rideau is not competent?
None that I'm aware of, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of tampering or fabricating with physical evidence. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This will run concurrently with all of your other felonies, which is specifically cause numbers 23 DCCR 0928, 23 DCCR 2106, 2107, and 24 DCCR 1925. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, ma'am. You can go back with the bailiff.
Thank you.
All right, ma'am. Again, you're Gabrielle Smith.
Yes, ma'am.
Gabrielle Smith, I'm sorry. Mr. Kimler, Ms. Malthino.
Well, I was left to state lead, Your Honor.
Judge, we had previously been before the court on a PSI, and the court understandably, based on that PSI, rejected the 5-year cap. I then made an offer of 8 years, where I still am today. Mr. Kimler wanted to argue, and obviously that's his right to do before the court for maybe a little bit less time than that, but I didn't feel comfortable making any other offer myself without the court's input or permission. Obviously, her original PSI, her criminal history is horrendous. Now, the facts
PSI?
of this offense on their own obviously are not super egregious, but the history is, and so that's kind of what we work.
I guess, I mean, if y'all, if y'all want to do a cap of 8 instead of the 8, I would take a look at that, and then we could talk about that, and then I would, obviously it's something that the cap is what it is, and then I've got the PSI. I don't know that I would need an update, but if you needed time to put something together, then we could reset it for sentencing if y'all wanted to enter that plea today.
Obviously, I don't have the priors in front of me. I requested them from Louisiana. I
Okay.
don't want to represent 100% that I believe Ms. Smith is habitual. I do feel very confident that there is more than enough to get me there in proceeding in trial. That would be what I would like to do. Again, the underlying facts of this offense, standing alone, don't appear super egregious, but in combination with the history, I would feel better with a cap and allowing Ms. Smith to make argument on her behalf.
Sure.
I certainly won't stand in the way of that.
Okay. All right. If y'all want to visit about that, do you want to visit today about that, Mr. Kimler? Do you want me to? I can reset it a week or so if you'd like some time. Sure. Okay.
Thank you, Judge.
Okay.
NTR.
Perfect. Sir, you're Leonard Guillory? And Mr. Guillory, Mr. Lewis has let me know that your family has the intention of trying to hire an attorney. Is that correct? So what I'm going to do is reset your case, a normal reset. That's about 30 days. Mr. Lewis is still on your case. Unless they hire someone between now and then they'll file the appropriate paperwork to get on your case. If for some reason they're unable to, then when we come back, you'll need to discuss your cases with Mr. Lewis, and then we'll go forward that way. Okay?
It was I just wanted to point out, I did talk with Mr. Gillard. He did have an issue about his, of course, his bond. I told him that I could file that necessary paperwork. And then, of course, if Mr. Kimball wants to adopt it, he can, but
Sure.
it'll already be in process.
All right, and so if Mr. Lewis or Mr. Kimmler or whoever else files a motion asking me to reduce bonds or anything like that, then we'll set it for a hearing very quickly, and I'll hear that at that time. Okay, you can go back with the bailiff.
All right,
Thank you, Mr. Lewis. Mr. Matuska, did I see on Michael Brasher? And Mr. Brasher, in cause number 23 DCCR 0944, you're charged with aggravated assault against a public servant. And your bond conditions include having a scram device. Give me just a second to get all this pulled up, please. And I received an email from the alcohol monitoring company, Recovery Monitoring Solutions, on August 26th, that you had been non-compliant for not taking care of the maintenance or uploading your data from your Scram bracelet. And
For payment, Your Honor. To be exact.
well, for not taking care of the maintenance and for not uploading your data is what they said. And so if you're also not paying, then that's another thing that you're not doing correctly. But the fact that you're out on bond, that you made a $150,000 bond, and part of that bond, so that I was comfortable, was for you to have that Scram bracelet and for it to be working at all times.
Yes, ma'am.
So since then, I set it for a hearing for a bond review compliance, and Mr. Coleman has filed a motion asking that I increase your bond because of that non-compliance. Are you working?
I just got a job in the oil field, Your Honor, and my first check was just really 2.5 weeks ago, and I've been trying to get caught up on everything. Most importantly, I was trying to get caught up on my bond payments, and I still have that monitor on too. I am caught up on theirs. I was about to go and pay for them until I got the call and I got deactivated. So I have no failed alcohol or no failed readings. I'm also on probation.
But I don't know if you have failed readings because you weren't uploading
They
it.
were getting the data, Your Honor. They got the last data as soon as I got there too. The Corpus Christi office did. And I'm also on probation, Your Honor. I have to have a portable breathalyzer that I also have to test for them 3 times a day. Both, you know.
So you're on probation where?
In San Patricia County.
Okay. And you have a portable breathalyzer there?
Yes, ma'am. I'm supposed to have one for the vehicle, that one, and I was supposed to have this one too, but.
Okay. All right. So,
I asked for paperwork.
do you have any kind of proof of the San Patricio County conditions of that probation?
No, Your Honor, I do not.
All right. So let's do this. Obviously I want you doing what you're supposed to be doing on bond, but I also don't believe that it's necessary or financially probably to have a Scram, a portable, an auto ignition, and a GPS. That sounds like a lot. So what I'm going to do, I need you to get immediately to Mr. Matuska some documentation from your probation office in San Patricio County that you have that portable device. And what I'm going to do is order that instead of the scram, I'm going to remove that order, that condition order of your bond. And I'm going to order that you all have the portable device here also. That doesn't mean you have to have two, but I need that company to know that they need to also send us those results. And so, Mr. Matuska, if you can help coordinate that, we'll get that bond condition done. But I think I need that company's information so that our clerks can send that is now a bond condition to them, and they can keep us updated just like they're keeping San Patricio Valley, or this county. Does that make sense to you also, Mr. Coleman?
Yes, Judge.
Okay, so I'm not going to raise your bond today. I'm going to remove the scram, but order that you continue that portable device. I just need those results as well, okay? Make sure you make that a priority to get that information, work with Mr. Matuska. If I'm not getting those results, then we're going to be right back here, and I'll have no choice but to raise that bond. Okay, all right, you can go.
Excuse me, this was a re-indictment from 23 DCCR 1034. I will dismiss that if I have not already.
It's not showing up on the docket, so I think it might have already been done, but we'll check.
Just wanted to let you know, we went from just a robbery to an assault public servant. I think that tracks the
Okay.
facts better.
Thank you, ma'am. And will your client waive the formal reading of the indictment?
So,
Ms. Smith, in cause number 25 DCCR 0979, you're charged with a second-degree felony offense of assault on a peace officer, and that's from June 10th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal.
Yes, ma'am.
And the agreement is for a cap of 8 years in prison, which means you're leaving your sentence up to me. And as long as I give you either 8 years or less, you're waiving that right to appeal. You understand? You have an absolute right to have a jury come in and decide two things. The first would be to decide if you're guilty or not. And then if they find you guilty.
Thanks for watching this courtroom breakdown. This case raised serious questions about public safety, bond decisions, and how judges balance the rights of the accused with the protection of the community. What did you think about the judge's ruling? Do you agree that the bond should have remained at $10 million, or should the defendant have been given a chance at a lower bond? Let us know in the comments below. If you enjoy real courtroom footage, legal analysis, and true crime cases, be sure to hit the like button, subscribe to the channel, and turn on notifications so you never miss an update. And before you go, check out another courtroom case on our channel where a judge faces an equally difficult decision with life-changing consequences. Thanks for watching, and we'll see you in the next video.